Good morning. My name is Malcolm Neekirk. Welcome to Fretton's 10th coffee break briefing of 2023, and welcome also to what is now our 4th year of regular coffee break briefings. As long as you keep turning up, I'll keep turning up too. Now, if you do watch this and all the briefings planned over the next 12 months, you will, of course, be able to log nearly 6 hours of verifiable CPD. And remember too, if you do miss one, they are all recorded, including this one, so you will have an opportunity to catch it later. Now, as I always do, I'll give you another reminder to try out the retention of title website tool I showed you earlier this year. Why not scribble down a quick note to yourself to have a look at it at the end of this morning's presentation? I'll also remind you now that I do pre-pack evaluations. I'll be happy to give your buyer an estimate for my fee as an evaluator if you are selling to a connected party soon after your appointment. If you'd like to ask any questions during the presentation, please ask through the question box. I may pick them up as we go, but it's more likely today that I pick them up at the end. I hope to finish my presentation by 11 o'clock, but I may go on beyond that if I need to deal with questions. Right, so that's the housekeeping dealt with, so I'll now start the presentation. Welcome to today's presentation on Berkeley Applegate orders. If you've been doing insolvency for any length of time, you'll have come across Berkeley Applegate orders, I'm sure. And for those who haven't, it's a slightly technical subject, hence the subtitle. Today's presentation is about dealing with stuff that's not yours. Now, the sort of scenario when you might find yourself talking about a Berkeley Applegate order is something like this. You will have been appointed probably as liquidator to a business which has now closed. It did handle other people's money. It may have been an investment firm or an estate agent or a professional services business, or it might just have been taking customer deposits with orders, something like that. I hope for your sake there will be some assets there for you to deal with, but as we're talking about Berkeley Applegate orders, there will also be a client account, and there will be less money in it than there should be, and consequently there will be a muddle that needs to be sorted out. And this then brings me to some of the questions that you might be asking at this stage. When it comes to thinking about the money in the client account, among those questions are likely to be these two, not necessarily in this order. Question one, can you use the money in the client account to pay for the expenses of the liquidation, including your fees? And question two, this is a muddle. Somebody has to sort it out. Is this the job of the liquidator to sort it out, or should somebody else be doing it? And if you do it as liquidator, will you be able to charge for your time and expenses working on doing so? And for the second question, this is where Berkeley Applegate kicks in, and it gives a complicated answer. So to put that answer into context and to put the issues into context, I'm going to start with the first question, whether you can use the money in the client account to pay your fees. And I'm going to start there by quoting a bit of Latin to you, nemo dat quod non habet. And this means, as legal Latin normally does, that this is going to get complicated and expensive in terms of legal fees. Specifically, the usual translation of nemo dat quod non habet is nobody can give what they do not have, or to rephrase that in more modern English, if you don't own it, you can't sell it. Now, in fact, it's not quite as straightforward as that because, as I'm sure you would have seen professionally, people quite often sell stuff that they don't own. So what nemo dat quod non habet is all about is looking at it from the buyer's point of view. And the buyer's point of view is, as buyer, you've paid for it, you think you've bought it, but now it turns out that the seller didn't own it. And so in many cases, because the seller didn't own it, now neither do you. Now, there are lots of exceptions to the nemo dat rule, as it is sometimes known. There are circumstances in which somebody can sell something that they don't own, and the buyer will become the legitimate owner of it. I'll cover that perhaps in another coffee break briefing, but I'm just going to pass on from there to talk about ownership and trusts. Now, as liquidator, you control the company's property. It's your job to realize the company's property and distribute it to the creditors of the company, and you are entitled to take the expenses, including your fees, of that process from the property of the company. In a case where Berkeley Applegate is going to be relevant, there will be a trust account, and although the trust account is in the company's name and therefore under your control as liquidator, the question is, do you own the money in the trust account? And by you, I mean the company in liquidation. Is that the beneficial owner of the money in the trust account? And to look at that particular question, this is all familiar stuff to you, so forgive me for just putting up a slide here, which is a quick refresher about ownership and trusts, legal ownership and beneficial ownership. These are the two types of ownership that are recognized in law. Legal ownership is official ownership, ownership on paper. The legal owner is the person who has the documents in their name to prove ownership of it. And when it comes to selling whatever the property is, it'll be the legal owner who has the job of signing the necessary paperwork to pass ownership to the buyer. But the legal owner is not always the economic owner of the property, and this is where the second type of ownership comes in, beneficial ownership, which is the economic ownership, what I like to think of as the real owner of the property. And I suppose one test of beneficial ownership is who gets the money when the property is sold, who is entitled to the realizations. That's the beneficial owner, and you will sometimes find that the legal owner and the beneficial owner of a particular asset are different. And there is a trust every time you have that situation where the legal owner and the beneficial owner of property are different. And in such a case, the legal owner is the trustee of the property, and the beneficial owner is, of course, the beneficiary. And also, by some peculiar quirk of English land law, whenever you have two or more owners of freehold or leasehold property, the legal owners, of course, being those named at the land registry as the owners of the property, whenever there are two or more legal owners, there is automatically a trust established, even though those two named legal owners may also be the people who are entitled to the proceeds of sale and are also therefore the beneficial owners. Nevertheless, English land law works so as to create a trust whenever you have that situation, two or more owners of property. It's something they teach law students very early on, so we don't realize quite how weird it is at that particular point. You're going to come across that situation of freehold or leasehold property in joint names quite commonly in the context of personal insolvency. That's not what I'm going to be talking about today. I'm going to be talking about the trusts you might find when you're winding up a business, and they're more likely to be things like customer deposit, client accounts, and so on. And in cases like that, the company itself will be the trustee of those accounts. The customers, the clients, will be the beneficiaries, those entitled to the money in the deposit account, in the client account. Let's just give you a scenario of when you might find a customer deposit. So think here of a customer who walks into the showroom, places an order and pays a deposit, let's say £5,000 on placing the order with the business. Now the dealer has got a customer committed to the purchase, they will now order the goods so that they can complete the work, sell the goods on. And this might be a car showroom, it might be somebody who's coming to buy a new conservatory or a kitchen, something like that. And let's suppose that in this case, the dealer closes once they've taken the deposit and you are now appointed the liquidator. In that particular case, the supplier, of course, will not deliver the goods to the dealer has closed, and the customer will quite naturally want their deposit back because they will have seen no value for it. Now, it's all pretty straightforward, I suppose. If the customer paid the deposit in cash, the cash went into an envelope with their name on it, and the envelope went into a safe, because you can then clearly allocate that cash to that customer, that order. But that never happens, of course. It will all be money that's gone into a bank account, and you may well find the customers are claiming that the money they paid to the business is now held on trust. Now, to assess that, the main things that I think you're going to need to look at are, firstly, what did the contract say? Did it say anything about the refundability of the deposit, whether the deposit is to be paid into a trust account, anything of that sort, anything to indicate who that money belongs to once it's in the hands of the dealer. Second thing is, how is the bank account actually described? Is the title of it set up as a trust account or a client account? Third thing, and almost the most important, is the money still there? And if the money was originally paid into an overdrawn bank account, or if the account has since moved into overdraft, the money has gone. It's been used by the company to repay part of the debt it owes to its bank. You can't get it back in a situation like that. But if the account is in credit, then there is money in it, and you may be able to use the tracing rules that are sometimes used to identify whether any of that money actually belongs to this particular customer, or whether it was originally paid by this particular customer. And if the deposit went into something that is clearly a client account, then a client account is a trust account. It means that the business owner, the company who provide the signatories for the client account, they are the legal owner of the bank account, but the clients will be the beneficiaries. They will be entitled to the money in the client account. And if the client account has been run properly, then the balance in the client account will, of course, match what is due to clients. But we're not looking at a scenario like that. We're looking where there is a mismatch, where there's a shortage of funds, and hence you're looking at possibly getting a Berkeley Applegate order to sort things out. Now, examples of the sorts of businesses who operate client accounts, they include some businesses that take customer deposits. Not all businesses that take customer deposits will pay the money into a client account. Many of them will simply pay the money into the main bank account of the company. Accountants generally operate client accounts. Insolvency practitioners do, of course. Most solicitors do. Estate agents frequently do, particularly if they're letting agents or management agents. And many financial services businesses also operate customer accounts. And there are many others as well. So let's go back to the first of those two questions I originally asked. Can you use the money in the client account to pay your fees? Well, the short answer is no, you can't, because the client account is a trust account. So although the legal owner of that money, the legal owner of the account, is the company and you are liquidator of the company, despite that, the beneficial owner, the economic owner of the funds in the client account, are the customer's clients or customers. And therefore, It's their money, it's not the company's money, it's not part of the assets that you are entitled to deal with and distribute to the unsecured creditors, and therefore it doesn't form part of the funds that can be used to pay the expenses of the liquidation, including your fees. So that then moves you on to the second question. The client account is a muddle. Somebody has got to sort it out. As liquidator with access to the records, you're the logical person to be doing it, but if you do it, will you be paid for it? And the complicated answer from Berkeley Applegate is yes, sometimes you can, but. And so let's look at that in a bit more detail. Let's look at this complicated answer that Berkeley Applegate provides to this question. And probably the place to start is actually the case of Berkeley Applegate itself. And I must confess to a certain fondness for this case because I was actually involved in the periphery of it in the mid-late 80s when I was acting for one of the investors who faced the prospect of losing money when Berkeley Applegate went into liquidation. Now, Berkeley Applegate was an investment company. And this is the way that it worked. Its investors would place their funds with Berkeley Applegate, and Berkeley Applegate would then lend money to small businesses, always on secured loans, backed with mortgages on properties. So the investors' money would be onward lent to businesses that were asset backed, had properties and could give mortgage security for the loans. The investors were generally individuals. Berkeley Applegate advertised quite widely in the local press. It was a company based in the southwest, in the national press, and actually in the religious press. So when they went into liquidation, an awful lot of those who were concerned about what was happening to the company and their investment were people like orders of nuns, the senior monks at various abbotries, and other religious communities, which just added to the story in the headlines as it was reported in the papers at the time. So the problem that the liquidators faced is they had to decide, firstly, there was uninvested money in the client accounts. Who did that money belong to beneficially? Was it the company or was it the investors? More significantly, there were the funds that had been invested in mortgages, in loans to other businesses. And as and when those mortgages were repaid or sold on by Berkeley Applegate to other companies, who did those mortgages belong to beneficially? Did they belong to the company, in which case the realizations would go into the general body for unsecured creditors, or did they belong beneficially to the investors, in which case that money should be ring-fenced and should be used to repay what was due to the investors to the extent that was possible. And if it turned out that the client account and the mortgages did not belong to the company, could the liquidators then investigate the investors' claims at all? Could they actually ask the investors to provide evidence of their investment? Could they assess how much was owed? Could they do any of that work? And if they could do that work, could they use the investors' money to cover the expenses of doing that? They couldn't use the company's money to do that because this was work outside their normal functions as a liquidator. This wasn't work that was being done to benefit the unsecured creditors. This was work that was being done to benefit people who had property rights, ownership rights over assets that the company had got. And nothing in the Insolvency Act allows them to charge the cost of doing that to the general body of creditors. And similarly, there's nothing in the Insolvency Act or the insolvency rules that gives them the right to use third-party funds somebody else's money to cover their expenses of dealing with that. So to try and sort this out, the liquidators applied to court to ask for directions about what they could and should do in a situation like this. And of course, as you would expect in an application to court for directions, the investors were legally represented, and so too were the unsecured creditors. So the judge was able to hear arguments from all of those with an interest in this. And the court made a ruling, one that was actually very sensible and very, very useful in terms of sorting out this particular situation and many others similar to it that have happened since. Firstly, on the facts, the court decided that the money in the client account belonged to the investors, not the company, therefore was not part of the funds that the liquidators should be dealing with as liquidators. And also as a fact, the same thing applied to the mortgage loans. Beneficially, those also belonged to investors and not to the company. But then the court didn't want to leave the investors and the liquidator in the situation where there was a problem that needed to be sorted out and no mechanism by which that could be done. So the court then expressly gave permission to the liquidators over and above their statutory authority. They were given additional permission to charge against the investors' funds the costs of identifying the investors' assets, managing them, and accounting to the investors effectively. The court recognized that the liquidators, by virtue of their authority to deal with property that the company was the legal owner of, they were able to sort out the investors' assets, but they were given an additional authority over and above the authority they've got in the Insolvency Act to charge the cost of doing that to the funds that they realised in doing it. But they were specifically not allowed to use those funds, the investors' money, to pay for the general work that they were doing on the liquidation. That should be charged in the normal way to the assets that are realised for the benefit of the unsecured and preferential creditors. So that was the first Berkeley Applegate order, and there have been many others made subsequently, and it's a really useful approach if you find yourself in this situation where there's perhaps doubt about who is the beneficial owner of assets that are in the company's control or custody or ownership. And it seems sensible for you as liquidator to sort out those assets and to realise them and administer them for the benefit of those investors. But the key points about Berkeley Applegate orders are these. Firstly, Berkeley Applegate does not automatically extend the rights that liquidators have got. It's not a case that as liquidator, you've got all of your powers in the Insolvency Act, plus those described in the Berkeley Applegate case. If you need powers similar to Berkeley Applegate powers, you have to go to court and ask for directions to confer those powers on you. If you need to charge for unscrambling client accounts or anything like that, you can do it, but you need to go to court first to ask for permission to do that. And you shouldn't assume that this is going to be a rubber stamping exercise. The court will not always grant a Berkeley Applegate order. And there have been, in the last couple of years or so, a number of situations, particularly dealing with fractional ownership schemes, where the courts have been very reluctant to extend the scope of Berkeley Applegate orders to areas where they do not automatically apply. By fractional ownership schemes, I mean developments like hotels or student halls of residence, where as part of the the plan for developing the site, individual units have been sold to individual investors. So people are given the opportunity to buy a hotel room and the income that that generates, or a studio apartment in a hall of residence and the income that that generates. And some of these schemes have been so efficient that they've actually sold the individual hotel rooms or the studio apartments before they were actually built, which then leaves investors owning a lease of an area of fresh air above a building site. And in cases like that, the courts have been reluctant to extend the scope of Berkeley Applegate orders, because what you're looking at there is actually not somebody who's just got a beneficial interest in the property, but somebody who actually has legal ownership of a lease. And it might only be a lease of fresh air with the breeze blowing through it, but nevertheless, it is legal ownership of something. To get a Berkeley Applegate order, you have to show that the work is necessary to protect the interests of the beneficial ownership, of the beneficial owners. So this is not something that is being done simply to assist the unsecured creditors, or simply something that's being done because there's not much of a fee in the job unless you roll your sleeves up and get stuck in with this. You actually have to show that it is in the interests of the beneficial owners that this work is done and that you are the appropriate person to do it. And if going to court to get a Berkeley Applegate order, you should also remember that there's more than one way to deal with the funds in a case like this. You might find that, for example, that the most appropriate way of dealing with this might be to pay the available funds out in proportion to the investors and their claims, or it might be more appropriate to actually trace through and try and allocate individual investments to individual investors, which means that some investors will do rather better than others. There's no single best way of doing it, but it does make sense if you're going to court to ask for directions for authority to do all of this, to actually explain to the court what method you are proposing to use to deal with the funds once they're realized, and on the basis that the investors and the unsecured creditors are likely to be legally represented, then the arguments for both sides can be properly heard on that. And similarly, if you are going to be looking at tracing funds, there is more than one way to trace funds. The most common is first in, first out, but you can also use first in, last out, and there are other ways of doing it. So if you're looking at tracing through the funds to try and track where they've gone, again, it makes sense to ask the court specifically for a direction about the method that you think is going to be the most appropriate for the tracing exercise. And the final point on Berkeley Applegate orders, and Jeremy, I think this may answer the question that you've raised, is you should always ask beneficiaries first. Certainly tell them what you're planning to do, so that you've got an indication before you go to court as to the strength of feeling and what the views are. And if there are a small number of beneficiaries, which was Jeremy's question, then yes, you may well be able to you may well be able to get the beneficiaries to agree that you should do the work, in which case you won't need a Berkeley Applegate order. But it's one of those situations where I think you would need unanimity of the beneficiaries. You couldn't do it with on the basis of a 50% majority or a 75% majority, I think you would need unanimity. And if you don't get unanimity, then you might have to go to court for it. And of course, the agreement that you reach with the beneficiaries should be carefully used to the agreement you have with the beneficiary should be carefully prepared to make sure it covers the points that you need to. I am getting some questions in now, so I'm just having a look at those because these seem to be relevant. Claire has asked a really good question, which is what funds did the liquidators use to apply for the court direction? The example being, of course, that if there was no money other than those in the client account, would it be reasonable to use those funds to apply for court? I don't know the answer to that, and I'm afraid the best answer I can give is that the only rule about costs is that there is no rule about costs. So I think in a case like that, you would actually have to be fairly confident that you are likely to get a Berkeley Applegate order, in which case there would be the likelihood that the court would allow you to use the investors' funds to cover the costs of the Berkeley Applegate order. Again, I think you could protect yourself in advance to some extent by sounding out the main investors and seeing if most of them accept the need to apply to court for a Berkeley Applegate order, and consequently accept that you are likely to be charging the fees for doing that. And yes, if you get unanimous investor support, that's absolutely fine. But I think if you've actually put the question to the beneficiaries, the investors in advance, and you said, look, this is the court order that we think we're going to have to apply for. These are the terms that we want. What are your thoughts on it? Bearing in mind that an application to court looks like it's going to be necessary unless we get unanimity of investors, and the costs of applying to court will have to be charged to your funds. And if you go into court having had that sort of dialogue with the investors about it, at least the judge can see that it's been raised, and it's more likely to look reasonable if you've discussed it with the investors and taken on board any legitimate concerns that they've got to the extent you're able to. So question here from Freddie, another excellent one, is what work do you need to do before you apply to court? And again, this is another one of these situations where, yes, you are going to have to do quite a lot of work before you apply to court to assess what the funds are, what the scope of the problem is, to make sure that the court is properly briefed, to ensure that you've consulted the investors. And yes, all of that is work that you are going to be at risk on when it comes to making the application, because if it's refused, you won't be able to charge that work. So you'll have to do it on the basis of really taking a punt on it. Again, as with the previous question, if you're able to clear it in advance with the main investors, that's going to be helpful, but it's not going to be any guarantee that the court is necessarily going to give the answer that you want. And I think that is all that I've got on questions so far. If there are any others, I'll be very, very happy to take them, but this is the point where I was expected to have questions anyway. So while I'm just waiting for any more questions that may come through, I'll just remind you of a couple of key dates for the diary. Next coffee break briefing is on the 4th of December, where, following my tradition in talking about long forgotten old cases that everybody thinks is irrelevant these days, I'll be talking about centre binding. And if you've not come across centre binding, it is the situation where a liquidator is appointed in an insolvent liquidation, in a CVL, by the shareholders only, and has limited powers before the creditors can ratify the liquidator's appointment. It's generally regarded as being a fairly courageous thing to do, to be involved in centre binding, but there are occasions when it is actually the right thing to do, it's a sensible thing to do, and so I'm going to be talking about those. So that's next month on the 4th of December. And I would also like to invite all of you to come to our third insolvency conference in 2024. We haven't yet got the date, but it's likely to be May or June, I think. We haven't yet got the venue, but I think it's likely to be somewhere around about the western border of the New Forest. So if it's not an area of the world that you know too well, it'll be a good opportunity to come and visit, I hope, on a Friday. And it will, of course, be 4 or 5 verifiable CPD hours at a very, very good cost. So I do hope to see as many of you as possible there. And with that, I don't see any more questions. I'll just have a final quick look. So no, I think that's all questions answered. So thank you all very much, and I look forward to seeing you next month on the 4th of December. Thank you all very much, and goodbye.